a chance to read the answer to that? Okay. Yes.
I'm a little confused. I thought that I responded to your email, but I
Yes.
don't know that that was broadcast to all the other
Oh,
commissioners.
okay.
So they probably
Sorry.
don't have what I said.
They don't have, all right. I can go ahead and read then your answer to that, and then if there's any further questions, we can go ahead. Okay, David's answer was, to my knowledge, there is no empirical data proving that lower density development uses less water than higher density, but it seems very likely. 4 homes on 5-acre lots would surely draw more water than 1 house on 20 acres, so long as the 20-acre parcel is not irrigating for agricultural purposes. What we know for sure about this area is that the geology is fractured basalt, so unlike land over the Rathdrum Prairie Aquifer, water sources in this area are highly unpredictable. Any further input on that one, or further discussion or questions from commissioners? Commissioner Zao, does that answer your concerns?
Yes, it does. Thank you.
Commissioner Malloy questioned why the county is dealing with this rezone request if the tribe has authority in subdivision decisions.
I think you missed one.
Yeah, okay. He had further questions about the country designation, impact of that designation on the commission's eventual recommendation. The answer was, because the country designation encourages subdivisions, I'm thinking it would be better to leave this area out of the rezoning request for now and circle back with the future land use map amendment to the comprehensive plan before rezoning this area.
Okay. Madam Chair, Commissioners, Pat Braden, Civil Deputy Prosecutor, for the record. I also provided a comment to both Director Callahan and Chair David that I was of the opinion that those parcels that are within that area designated as country where the owner has consented to the rezone could still proceed. Otherwise, I do agree with Director Callahan's comment.
I do have one follow-up question for Director Callahan, and I understand the logic there, and I kind of believe that there's a ways around that, but I think that the right decision is to do that. However, the question I have is more, if you use the logic that future land use map is the roadmap of what we have to consider when we make changes to zoning and other land use codes, if you believe that, which we do, then am I correct in the assumption that any subdivision request in that area would also require your department to evaluate a subdivision based on what the intent of country designation was, which was low density, not requiring a lot of services, protecting the environment, water, and everything else, so that while we do not rezone that or recommend a rezone, if that's what we do, that any request for a subdivision would still be under that assumption of what the intent of that was.
Yes, sir, I believe that's the case.
Thank you.
Any further discussion on that question for the moment?
Clarification, then what does that mean?
If we get a request, let me back up, assuming that this goes through and country is left out,
Okay.
and so it remains rural,
So it has a country designation, not
and
subject to,
and rural zoning,
and it's rural. Got it.
and we get a request for a minor subdivision.
Got it.
It's a little hard to predict what the tribe might or might not do under those circumstances, but assuming they've done in the past what they've been doing, excuse me, in the future what they've been doing in the past, then we're in a predicament of weighing that response against what the comprehensive plan says. which, going back to Mr. Levine's question, we must review in its entirety. So we can't pick and choose and just say subdivisions are encouraged. We have to read that, everything that David just read. Does that help?
That's pretty murky for me.
Well, it's pretty murky for us.
Yeah.
That's among the reasons why I'd like to get some finality to this,
Yeah,
ultimately.
The reason I asked the question was more about the fact that the code for rural says, here's what you have to do to have a subdivision. The parcel sizes and all these other requirements. Normally, if you meet all those requirements, a minor subdivision outside the boundaries of the Coeur d'Alene tribe would more than likely be approved. My question was, if the person within the country designation provides all the same information, would it be approved, or would it be evaluated against the code plus what the land use, future land use map says, which is low density, no cluster housing, and all that? So there is a slight difference in, this is more restrictive of a minor subdivision than outside the country designation. Is that fair?
Let me frame it a little differently.
Okay.
and
I wasn't
need
hearing it
Pat
that
to weigh in, but my memory is the Land Use Development Code criteria for a minor subdivision require that we compare it against the comprehensive plan. And in the comprehensive plan, we have to look at everything. Pat, is that your memory?
I'm actually.
Looking it up?
Yeah, I'm not trusting my own memory, so I'm looking it up real quick.
Thank you.
I'm right there. I just need to.
Thank you.
Well, just make it up as you go along. We'll never know.
I've winged it enough times in my legal career. I think this one I need to. Yeah, the approval criteria for a subdivision, whether major or minor, does not expressly refer to the comprehensive plan, but it does, have enough criteria that relate to goals and policies in the comprehensive plan that it's, that can be looked at for that particular, the future land use map designation in the particular area it's in, and weigh it against the criteria that are in code to see, if, the comprehensive plan could provide reasons to supporting an approval or a denial, even though it doesn't expressly say, shall substantially comply with the comp plan, like it would for a conditional use permit, for example, or a zone change.
But Mr. Callen, in your answer, it sounded to me, from what you said, that what primarily weighs most heavily is the tribe's position. Not so much.
That's my concern.
Not so much the nuance of this factors in, but the overriding concern you seem to voice is if the tribe maintains its current position on no development.
Yes, because that puts me in a difficult spot, frankly. Is that either way we go, we have the potential of being sued.
Which is certainly not unique to this circumstance, but,
No.
it was certainly one in which that is, in play.
Further comments on that question? Well,
No,
I think
but I have
we'll go
another
back
question
to.
after that.
Okay, go ahead.
I just had a question for Attorney Braden. In the Montana cases, this one line, a tribe may also retain inherent power to exercise that line. If you remember that to exercise civil authority over the conduct of non-Indians on fee lands within the reservation when that conduct threatens or has some direct effect on the political integrity, the economic security, or the health and welfare of the tribe.
Mm-hmm.
Is that the language? My question is that the language that you've been focused on that is the exception in the
Yeah,
Montana case?
the exception that would most likely apply here. Absent some sort of consensual relationship with the tribe that a court could focus on. The second exception would be the one that's germane.
That's the exception, though. Is that the language? I'm
The
trying
one
to
that
pinpoint.
the one that you just read.
Is that
second
second exception?
exception, yes.
Okay. Yeah. Okay.
Any further questions on that at the moment?
Yeah, that's all I just wanted to clarify.
Okay, the next question was from Commissioner Malloy, questioned why the county is dealing with this rezone request if the tribe has authority in subdivision decisions. In short, because the existing situation is untenable and because the tribe may not have authority in the case of a non-member fee land. We simply can't know until or unless this goes to court. In the meantime, and if we can rezone areas for which there is no argument, then those affected owners are better off with the certainty of knowing what's possible without having to go to court.
And Madam Chair, Commissioners, I just have a supplemental comment on that I did provide to Director Callahan again and to Chair David on this. And I'm actually quoting a letter from Chief Allen, who's the chair of the Coeur d'Alene Tribal Council, and he is here behind me. I'm just going to quote from his letter like I did in the email.
Okay.
And I agree with Director Callahan's comment that you just read also, but I think this goes into it a little deeper. It says, some have criticized the offer to include tribal lands as meaningless since the county does not have regulatory jurisdiction over the tribe and the tribe is not relinquishing that authority. However, the effort would be meaningful since that zoning change would affect future owners of the land should the tribe ever sell them. The change would reflect the actual use of the area and protect its irreplaceable resources, including the rural character, ag and timber resources, water supply, and the lifestyle of those who live here from the impacts of development. Each subdivision development diminishes and erodes those resources and imposes real impacts on those who live here, especially tribal members. These are clear public purposes which benefit not only the tribe but all those who call the area home. So I think that's a real succinct explanation of why the tribe is here and why the tribe asked the county to begin this effort. I was going to say something. Oh, the second to last sentence I read goes to Commissioner James' recitation of what's called the second Montana exception. Basically, where something that a non-tribal entity, whether it be the county or private landowner, does would have a very real deleterious impact on the tribe as a whole. And it's kind of one of those deals where the more development occurs, the stronger their argument gets. So I just bear that in mind in making a decision on this proposal.
If I could follow up on that, just a question.
Sure.
How this works, but to me that kind of seems like a conundrum because I was analyzing the study and I was thinking of if you apply the second Montana exception, at what point in time does development tip to the point that it triggers that exception? So
That's a good question, and I don't know the answer.
well, it seems to me the answer is unknowable because it requires one to project into the future
Right.
and try to figure out, okay, how much development would it take to trigger the exception, right? That's kind of
Right.
where we're at. And so one could analyze it this way, saying, well, it's always been pretty rural down that area or open, probably won't be much development, it probably won't be triggered. One could also say that you look north of Coeur d'Alene, everything's been developed that almost can be developed, or it's been developed quite a bit, and the next place to go is down south. And so now down south, we're ripe for massive development. I think that's probably a concern. I'm just pointing out, it really is a difficult analysis because it requires one to sort of anticipate what's going to happen without knowing it.
Well, I would agree, and I think it would just depend on, the level of, the facts that apply at the time, a hypothetical litigation is filed in the future. How much of that has occurred, how much of it is in the process of occurring or expected to occur. And it's.
See, that too is problematic, though, it seems to me, Pat, because you have one litigation, the conclusion of that litigation won't answer the question. because the next litigation will involve another development.
Right.
And that's a whole different fact pattern, because now you have more development, the tribe has a greater argument. Each time there's more development, the tribe has a greater argument.
You're
And
right.
so you can't get one finality, one final decision that would, in the litigation context, that would answer the question, if I'm right about that. Am I wrong? I mean,
I think you're right, and I think, that's a big reason, that they're here wanting to cooperate on this, as opposed to having to try to answer those questions down the road. I think doing something, at least doing something here would, preclude, at least to some degree, those questions from coming up.
and this is truly question and answer. I want to know your answers, because as you all know, my concern is the uncertainty and the
Right.
potential for ongoing litigation.
And mine as well.
That's the main focus I've been having.
Yep.
I believe that Commissioner Zao had one other series of questions that didn't get answered, and that was, does Worley have an ACI? If not, can they get one? And would the ability to obtain or expand an ACI be impacted by the zoning change?
I answered that separately, directly to
okay.
her. The answer is yes, that we do have an ACI, and I don't see Worley being directly affected on this one.
Okay.
By the way, I want to commend Commissioner Malloy on his question, because it was a very, very good one and took a lot of pondering on my part.
Okay, so really, we need to get down to making a decision today, or several decisions, as it may be. How would anyone like to approach this? We could approach it by carving out the country discussion and doing that separately, or we can go into the whole area. Any
I'd like
preferences?
to carve out the discussion.
Okay,
Sherry Zao here.
Madam Chair, before we go there, can I just make a
Sure.
comment? I wanted to really thank everybody and put in the record my gratitude to everybody that submitted additional materials. I mean, I'm showing them here, actually print them all out. They're really helpful. I read through this. There was some really thoughtful and well done analysis in those materials. I just want to reflect it. I'm glad we did postpone to receive this information. It was incredibly helpful.
okay, yeah. Would any of you like to have Aaron show his presentation and explain his new PowerPoint, new mapping?
Before I commented that, I missed Commissioner Zhao's comment. What did she suggest?
She said.
I wanted to talk about that country designation and consider maybe eliminating that from the rezone request in a specific area, though. And the reason I chose the area, if anybody can pull up the Kootenai County Future Land Use Designations map while you guys are sitting there. If you look at, if you compare that and you compare what the tribal land owns and the people that have said they would like to go for the rezoning, if you look at blocks 23 and 24 on that map, that's right below the Summit Bay Road. If you were to, we can't share the screen, but that looks a little different from the one that I have, the printout that I have. Anyway, but if you were to go take a look at that corner at Summit Bay, if you'll put your arrow on that for me, the Summit Bay corner of the map. The red corner.
It's down there.
Keep going. fun remotely, I tell you. Oh, you're close.
You're getting warm.
Get down to the lake. Okay. Oh, stop there. Oh. Go.
Hold it.
Oh, darn you.
Switch.
Okay, go up the red line. Up a little more to the corner. Stop. Now go straight across. Pretend there's a line there. Go straight across to the left.
Left. Out in there.
Yes. Keep going. And then keep going to the end of the base. Now go straight up. And then to the left. I know that that's an odd designation. I don't know what you guys have presented, but when I look at that area all south of that full line that I just asked David to do, it is either owned by the Coeur d'Alene tribe or in trust for them, or it is property that have indicated that they want to be part of the rezone. The area above that has a low
Okay, sorry, I am not able to be on video. I had a dentist appointment, so I had to.
Who is that? Can you mute yourself?
I just did.
Thank you. So the area above that has low numbers of people that are currently approving or indicating that they want to be part of the rezoning. And that's why when I looked at that and compared the maps against this, that's why I make that recommendation that that area north of that stake line I asked you to draw be excluded from the current rezoning request. Am I making any sense?
We have some questions about that.
Oh, that was a good.
This is the map with the opposition to it, right?
Yeah.
Yes,
So why would you?
I had created several
Back up
maps
people that are
for the last meeting, to find some others, based on direction received.
Aaron, would you turn
Do you
your,
have a map? Yeah, do you have the map that shows the people that, it was green hatched?
This shows the number of opposed, for which we've calculated 67 parcels. Now, there may have been a couple, this is as of yesterday, and a total of 4,065 acres. This shows the total number of support, 5 parcels outside of tribally owned or lands that are in trust status. I think it's also important to point out that we don't know how many tribal members own land in this area, so that is excluded from these. From our calculations, we only know what's either owned by the tribe, owned by the Bureau of Indian Affairs, or in trust status from the Bureau of Indian Affairs. There may be other parcels that are also owned by tribal members that we don't have a really accurate way to map at this point.
Okay.
And this is
Well, thank you.
and this is against the future land use map. We've done the same against the zoning map that I can show if you like.
So Sherry,
This is good.
so what is your proposal?
That was my suggestion, and so we can talk about it and see whether or not you guys think it's a bad suggestion or a good suggestion. But it was based upon overlapping the showing which ones were more tribally owned and wanted to buy in. based upon what I had previously. Any comments about my suggestion?
Right, yeah,
Lee?
there's too many buttons here for me. Yeah, I mean, if I understand right, the concept is to exclude, if we recommended the rezone, to exclude that area from the rezone. And if I'm understanding everything correctly, and I may not be, I think the problem with it, while it's a meritorious effort to try to sort of split the baby here, I think in one of these materials, somebody talked about us having Solomon's baby issue in front of us where we got split the baby. I think it doesn't solve the problem. If I'm hearing if I understand what I heard earlier about the conundrum of the tribe's objection to the subdivisions, by excluding this area, we don't solve the problem. And this is, by the way, because I live down there, I can tell you that is the hotbed area. That is the area that's going to be next developed. It is, these are the parcels at issue. They've been broken up into 20s, and the question is, are they going to be able to go to 5s? So to be quite candid, that is the hotbed spot. That's ground zero.
And that's why I asked the question I asked, was that if we follow the future land use map's intent, the developments won't be there because it won't be approved, generally speaking, because it is high density, it is cluster, it requires a lot of county services, it impacts the water and the environment. If you look at the county designation, it talks about it. The reason I think that this suggestion of excluding it is not because we don't think this map may have to be redone. If you look at the 2018 or whenever we did the comp plan, 19 comp plan changes, we specifically put a policy in to update the future land use maps because we knew they were outdated. This land use map was done in 2007. It was done for a useful life of 20 years. We're getting up to that number right now. So the reason it appears to make sense to exclude it is not because we're supporting or not supporting development in this area. Is one of the requirements, I believe, is to make sure that any changes to the land use code are supported by the comprehensive plan. I could argue, if I wanted to, that this subdivision intent was so minimal and so restrictive that making an exception to that could be warranted. I could make that argument, all right, and say that primarily there's two things that were allowed in this thing: agriculture and subdivisions. And the subdivisions were really restrictive. So you could say, and we don't know, I don't know what happened in 2007. Lord knows I don't know what happened in 1973 or 4, whenever it was, when they zoned this rural. But I do know what it says. And it says the future land use map allows subdivisions. So if we excluded it, the plan would be, our recommendation could be, to not only exclude it, but also request that the county immediately go and look at this future land use map to see if it's still valid, get the inputs of all the people there in that area and do that. Also, make sure that when they review their minor subdivision or major subdivision in this area, that they make sure that it meets the standards of the future land use map. That's the reason.
Yeah, but I'm not seeing how that advances the ball with what we're dealing with here, because the tribe will object to.
They may or may not object, but okay.
I just don't, I understand what you're saying, but I think it doesn't address the issue that's here today that we're having to address, and I don't think it advances the ball.
Yeah, I guess where you and I differ on the ball and advancing the ball is, I'm into let me start slightly different. Whether the county gets sued by the tribe or gets sued by individual property owners, that's the county's consideration. For me personally, you have a different view from your, all right? I'm looking at this strictly as a planning commissioner saying, what does the comp plan say? There are three things I look at. when I make a decision on land use code. What is the objective? It's very clear, the tribe has made very clear what the objective is. They want to preserve their land, within their tribal boundaries for agriculture, timber. They want to protect the environment. They want to save the water, make sure the water is sufficient for the people there. That's clear. Second thing, is the objective and the proposed change consistent with the comp plan? If the answer is yes, then the next question I ask, is the solution justifiable? Because that's a requirement in the comp plan also. We have to justify why we make a decision. So when I looked at this, I understood the objective. I believe putting country aside for a second, the other parts of the comp plan justify rezoning the whole area. With one gigantic assumption, which I can get into later when we talk about the other areas. This area, future land use map, is a little more murky about being supportive. That's the only difference. If we as a planning commission believe that the justification I gave about why you can include it is warranted, then we can include it. If we think that it is more likely to be sued because it has less legal standing, whatever the right word is, Lee, type of thing, then we could exclude it. But the intent is not to actually have this be subdivisions. So that's my logic. I'm not saying it's right. It's just
I still keep running into the practical problem. Whether you're pro or con development,
right.
The reality is the tribe's objecting and the county's sustaining the objection to development. So the status quo is you're in limbo. You really can't do anything because, and probably can't even get a loan because you don't know.
No, I totally agree.
And if we exclude this area out, that area is going to be still in that limbo.
But it may not be approved by the tribe or supported by the tribe for development, or the county using the land use map as a consideration, future land use map, may deny it because it is too high density.
Well, what I'm hearing is it puts the county back in the hot seat of the
I know, but that's okay. That's what David's paid for. I'm not saying it's the right decision.
All right,
There's two logics. I mean, that's what we have to decide. Sherry, I think, is recommending, Sherry, you're recommending to take the advice from staff, if I understand staff's recommendation, which is to exclude this and then go and do the update to the future land use map. The other logic is we could decide not to. I mean, that's really, we have to hear from David. We have to hear from my friend over here on my right and obviously from the chair.
Pat, is that what we just said? Does that change your recommendation at all?
Thank you, David Levine, Chair Levine, Commissioner Levine, for stating, making the statement that I wish I had done myself.
Back to my question, Pat, does that change your opinion? It's on. Does that change your opinion based of anything that was just said of whether or not you recommend taking it out or not?
Not really. I think, it's certainly something the commission could decide to do. Either I think either decision would be supportable. So I don't really, I'm neutral as to that. I would just reiterate my opinion that the owners, the land where the owners have consented to the rezone, proceed with the rezone. And I think Sherry's Commissioner Zayo's boundary is consistent with that.
Do you, I guess, I don't know, I guess this is for David. The protections against dense development, do you think those are sufficient enough to direct your your recommendations if someone brings forth a proposal?
Before I answer that, let me answer a question you didn't ask.
Okay,
I'm a little concerned of you jumping off of my logic and using it. I've been in over 1,000 public hearings in the last 43 years. And what I've learned from that is that these kinds of boards generally make a good decision if it's deliberative and based on facts. And I've learned to go with that. So I don't want you to substitute my thinking for yours. I really want this to be your thinking and your deliberations. To answer your question, I think the language in the comp plan is supportive, but as Pat says, there's no direct tie between the minor subdivision code and the comprehensive plan language. And so we'd be in that murky water again if we had to go to court that I'd like to avoid at some point, but my view again is this is an iterative process. Some of what you want is a lot better than none of what you want. I would like to see something go forward that's useful and we can always reconsider in the future.
I tend to follow Commissioner Leander's point of view in this, that I think in this case, the land use plan can follow the zoning change so that we can go forward and at least create a basis for decisions to follow. I understand the reasons why not. And I understand, why you made the point you did, sir. But in this case, I think it's probably not the right message to send to exclude those groups, because those are the very groups, as you pointed out, that are the most hot to go forward with development. And I think if we exclude them, we don't, you talked about not moving the ball. Well, maybe not, but it's at least brings everybody to the same spot at the same time, under the same rules, and we don't have split zoning in the whole area. So my point being is I think if we're going to do it, let's not exclude it, is my recommendation, just based on what I've heard. And I'll go further. I think it's time we make some recommendations and decisions, and I know the rest of you aren't ready, but based on what I've heard, there's a lot of reasons to equivocate. We're just kicking the ball down the road. There's nobody here that can say that this is going to be a finality. But at the same time, it's probably time we made some decisions. I'm going to recommend that we move forward with the request for all of the area as proposed, without exceptions, and that please feel free to modify, change, deny, but it's probably, there's lots of conversation we've had. I don't know that we have to keep reiterating it. We've had all the points about Montana law, and we've had all the points about why people don't want to do it. We've heard some great testimony on all sides, and there's been some great things presented. But in my mind, it's time to move forward, and I'm recommending we move forward with the change into the whole area. Now, from there, go forward. Please, John.
so comments.
Yeah, I have some comments, and it seems to me like the train, started back in July of 2021, and now it's running down the tracks without any brakes or any engineer. It seems to me, to go back to that meeting of July 15th, the proposal put before the Board of County Commissioners was that the tribe had come to David Callahan and requested that their lands be rezoned. And then it's on the tape. I'm assuming we've all seen it. We should. And the purpose of that meeting, I think, was to ask if we should proceed and go find owners of fee property, non-tribal members, to see if any of them wanted to come along. And that was what got the approval of the three commissioners at the time. Well, of the three commissioners at that meeting. And so there's so much uncertainty about this whole thing. It's very frustrating to me. And I'm a newcomer. I wasn't here then, or maybe I was in 21. but nothing happened, and nothing happened for that year and a half, all right? And so we go from what was referred to on tape as a no-brainer to now wanting to rezone the whole thing, including the whole thing, period. And and somebody said that it can be justified, or whatever the word is with the comp plan. What do you do with it? The SCJ came up with means, or the justification, I guess, and how it complies with the comp plan. Well, it doesn't comply with everything. It complies with some. And some of the ones that they didn't consider, at least on paper, they may have considered it and decided not to put on there, was the private property rights. And so the authors, you might say, of the reviewed or the updated comp plan, I've said it before, so I'll reiterate that they submitted to the county commissioners that in the introduction that the Planning and Zoning Commission in the county recognizes the primacy of private property rights. And the three commissioners at the time voted 2-1 to strike the word primacy, same word that the Attorney General of Idaho used in his guidelines for takings. They struck the word primacy and they put in the word, private property rights are kind of fundamental to the way we should think about stuff. And so the intent was that private property rights are primary, yet the county commissioners at the time minimized that. In our earlier deliberations, the concept of certainty was brought up, implying that if we make a decision, or when we make a decision, things will be certain, but there's no way that'll happen. There's no way that any decision we make today is going to bring certainty. So, and part of that uncertainty comes from the notion that if the zoning changes from rural to agriculture, then there will be no subdivisions allowed. But then the question, I'm assuming, we were told the question was put to the tribe that, well, if we go through with this rezone and subdivisions are not allowed, will you object to, I get hung up on that word divisions or subdivisions, but if someone wants to divide their land into 20-acre parcels, will you object to that? And it's my understanding that there was no answer. There was no answer to that. There was no yes, no, or there was no. And so to me, that's uncertainty. So if we're looking for certainty, it's not going to happen here. It's not going to happen with the decision we make today. So I think that Commissioner Dean just suggested that we go through with a total rezone on every parcel in the area. I think that's what he said, and I certainly object to that, because now every private property owner of fee land, however we say it properly, has had their hundreds of thousands of dollars in some cases taken away from them. I don't know, I mean, if somebody wants to join in, as the meeting of July 15th, 2021 was authorized to seek out, then I think that is a no-brainer to me. Anybody that wants to be included in a down zoning, I think that's part of the property rights, right? So go for it. That would be the tribe. And then the tribe, we were told at the public hearing, first they were told that the tribe came to ask for a rezoning of their tribal lands. I think that's a period. Will the county consider rezoning tribal lands? And then we were told at the public hearing that the tribe is not really interested in rezoning only tribal lands. So which is it? Are they or are they not? I mean, to me, that's just more uncertainty and more what I see as a train recklessly rolling down the tracks. So I'm a little bit discouraged that we're not talking more about the general concept rather than carving out country zoning or otherwise. Are you leaning to the mic because you want to cut me off? Or?
No, I would never cut you off.
Well, feel free. I think
Well,
I'm done.
actually, can I answer one thing, and then David, you could answer his first question? Why don't you just answer his first question, and I'll answer his second. At least I'll give him my opinion on your second.
Madam
Dave?
Chair, I don't really intend to answer any questions. I just want to clarify a point. In my view, it's not the subdivision exemptions that are at issue here,
Not now.
or in the future. To my knowledge, the tribe's not concerned about subdivision exemptions so much as they are minor subdivisions or major subdivisions. One of the questions I can't answer because I've never heard an answer, and it's no fault of the tribe. They reserve the right to not answer or answer. But I just don't know if we, hypothetically, is to say we leave out the country area, and then that area remains rural. And then a person comes in and asks to subdivide 20 acres into 4 or 5 acre lots. I don't know what the tribe's response is going to be. I can't predict that. I have an idea, but I can't predict it with certainty. But the subdivision exemption's been in the code one way or another since '73. And I don't see that really being the primary issue in front of you.
No, I don't see it as a primary issue either. But I do see it as a factor or potential issue to be addressed. I think that, and this gets back to the law, so to speak, of unintended consequences. I think that that if the tribe doesn't object to that kind of exemption, if we call it that, then there may well be numerous 20-acre parcels created from large parcels, which then is not the intended consequence at all. It's counterproductive to what we're talking about. It defeats the whole purpose. So I think
That is today's law, and it presumably will be the future law, even if this rezoning goes through.
understood. I think I'm done for the time being.
Yeah, John is right. We believed that the comprehensive plan should have used the word primacy of property rights because we believe, majority of the commissioners believed at that time that that was the appropriate word because the state law indicates it, a state has indicated, and it is fundamental. Everything you read about in the land use code, in the regulations that establish planning commissions, property rights are very much important. Downzoning, as I mentioned at the public hearing, is something I do not generally support. I believe that the county initiated downzoning. We have a policy, as you know, John, that basically said that should be minimized. But if we're going to quote the state law, we also need to quote the exceptions to the primacy of property rights, and that's health, safety, and general welfare. My thought on this issue, and this really comes down, I'm not saying it's right, I'm not saying it's wrong, but I view this very simply, and it's a complicated issue, but for me, I tried to break it down into a simple question. Does the tribe have the right to determine what the health, safety, and general welfare of the land within its borders? Do they have that right to say they believe that this is required to protect the safety and the health and the general welfare of their land? Now, I say their land, it's the reservation. People own, non-tribal members own land, but it's their, if you believe that they do have that right, I'm not saying you do. If you do, then it's a simple answer to me, which is you honor their request. If you don't believe that, and that's legitimate, and I respect anybody who doesn't believe that, then I would deny the request. Okay, and I would not even, the volunteer people want to do it. I'm actually wondering why they would. honestly. Because if you don't approve everything, if you believe the exception justifies it, then everybody's treated the same. If you basically let people opt in and opt out, some people will actually lose money by the fact that their land potentially would be less valuable because it can't be subdivided. So that's the only, to me, that's the issue. It's not an issue of unintended consequences or even any of all the other stuff we talked about, legal, whether it's legal, whether we're going to be sued or the county's going to be sued. We're only recommending something to the county commissioners who ultimately make the decisions anyway, okay? And I came to the conclusion, and you could argue that I'm wrong, and I respect you, John, you know that I believe we should honor the request. Now, I had a different opinion on the country, but I'm not locked in that, because I feel that, again, you look at the comp plan, what is the intent? And I think we're at a weaker position in including country. Am I opposed to it? No. But I think we're at a weaker position in using this. And the county, I think, is this correct? The county did lose a lawsuit a while ago because the comp plan, we weren't following the comp plan correctly. Was it up north? It was near Athol.
It was a sort out.
Anyway, it doesn't
No,
matter,
we-
but
it was,
wasn't a lawsuit? Okay.
well, basically, what happened was that, it was remanded back to the county.
Okay.
Because we didn't have adequate, criteria on which to make a decision on a zone change. So it was a defect within the code, which we later remedied.
Okay, thanks,
And
Matt.
they ended up not coming back with their application. They withdrew it. But it was because of a defect in the code, not in the comp plan, or not because we weren't following the comp plan.
Okay, thanks, Matt, for clarification.
This one?
I
Am
gotta
I-
start over again.
I gotta start over, all right. There were great comments, it's all really helpful to me. One of them was the concern about the train going down the track, the tribe changing its position or broadening it, one might say. In fairness, I don't think any party maintains their position consistently all the time. They often broaden or change or modify it based upon circumstances. I can tell you the circumstances here because I live down there and I see it happening. During COVID, a number of the large parcels started to get chopped up. I mean, in a short period of time, and roads started to be put in, and there was a lot of development going on in a very short period of time. And I think that's partly what triggered all of this, and the tribe's concern. And that's why they probably broadened their request here, if they did, because they saw this, probably this, oh my goodness moment where they see all this development going on within the reservation boundaries. So I can understand a change of position. The point about certainty is well taken. There is no certainty in life. We can walk out of here today and get hit by a car. But there's degrees of certainty, and each of us has to decide what decision creates the greater recipe for certainty. And then the property rights, I really want to address this. I think the analysis of property rights here, I believe a lot in property rights. I have property and I want it protected, and I want my rights protected, but you do not have a right to a zoning, and you don't have a right to a subdivision. Those are not property rights, and if I'm wrong, Pat the council will correct me, but these are not property rights. The property I own down there, I do not have a right to tell Mr. Callahan to give me a minor subdivision approval. That's not my right. And I'm afraid in the analysis of arguing for property rights, we start to lose what is a property right and what isn't a property right. And it also overlooks what may be the tribe's property rights within the reservation boundaries. And that is a murky area, and it gets us in the area of jurisdiction. But and this is probably why this decision is so difficult, because you've got two sides arguing against each other here, but I just want to clarify that, as to what the property rights are or not, and if I'm wrong, I need to be corrected.
Madam Chair, Commissioners, I just wanted to not correct Commissioner James, but just kind of comment on that a little further. Zoning, although it's not in itself a property right, like Commissioner James correctly stated, it does affect property rights, and we all know that. There is extensive case law that's basically saying unless a rezone goes all the way to the point of being a regulatory taking, that it can be done. I think as a matter of policy, I think the policy in the comp plan is correct that we should not downzone any more than absolutely necessary, or as someone may consent. But there are times where health, safety, and welfare may at least support that kind of a decision. So, one thing to bear in mind too is that a lot of the families that live down there have owned property going back several generations, and of course the tribe and its members since time immemorial. So, and most of that period was not zoned. So at that point, at the point where all that property was zoned, that actually, put a restriction on property rights wasn't there before. So there's at least that precedent, and, property can be rezoned, if there's sufficient health, safety, and general welfare reasons for doing it. Do we want to, downzone a property against somebody's will? I mean, that's a question you would have to answer. I think the general answer to that is no. But there are always exceptions. And that's why, the 7 of you have been appointed to this board, and the 3 people upstairs were elected to their board to make those kinds of hard decisions. So that's just my, kind of comment supplementing that of Commissioner James. And I'm not trying to tip this board to recommend one way or another. I'm just trying to make sure that the board considers all of the considerations that are in play here.
So,
May I? So
You may.
that brings up an interesting point, because Commissioner James says that we don't have the right to subdivide without going to the Department of Community Development, whether that's David or Scott or Rand or anybody who was in charge. It's not the person.
Unless it's a division exempt under the code.
But then you brought up the point that that didn't even exist until there was code.
That's
right?
true.
So there was a property right to divide our 5 acres or our 20 acres until zoning was born. And so now all of a sudden people have to come to us to ask permission what they can do with their property, whether it's us or whether it's the department. And so, it's, to me, 1970, 2 or 3, whenever, it doesn't seem that long ago. But that's when zoning took away property rights, right? Pat, our council just stated as much.
Yeah, and I agree, I stand by that.
The problem with that historical analysis is if you go farther back, the tribe had all the property rights.
Right, and, there was some compelling testimony in that regard at the public hearing.
Yeah, I understand. So, and I'm one of those guys then, I guess, that has to deal with the snapshot in time that we've got right now, and not go back to 72 or 1848 or whatever those days were, because none of us were here then, and I don't think I had any relatives who were here then. But so we need to work with that, like I say, the snapshot in time, which is where we are right now. And the zoning is rural, and it's being requested to be changed to agricultural, and that's my hang up. So I'm repeating myself now.
Okay, so right now we have a proposal on the floor to move forward with rezoning of all properties. Would anyone like to make that into a motion?
Commissioner Zayo's still on Zoom. Did she have any comments before we entertain a motion?
Nope, I'm listening. I'm just listening.
I'll change my suggestion to a.
I thought Commissioner Dean made a recommendation for that.
I'll change that recommendation into a motion.
All right.
Do I have a second?
No, I'd like to hear it restated, please.
The motion would be, and it can be restated or reverbed as needed to fit the situation, but to move forward with the zoning request as presented for the full area
Do I have a second?
with no exceptions.
I'll second.
Is that motion okay, Pat?
Yeah. Yes.
Head to a vote.
Commissioner Dean?
Yes.
Commissioner James?
Yes?
Commissioner Malloy?
No.
Commissioner Zayo?
Yes.
Commissioner Levine?
Yes, but yes.
Chair David?
Yes. Okay, we've got a, if not a solution, at least a suggestion for the Board of County Commissioners. So,
Madam Chair, I'm not sure of the protocol, but I would like to reserve the right to write a dissenting opinion.
sure.
You have the right.
Yes.
The one of the things that we have the right to do also is provide feedback to the county commissioners ourselves. So any one of us could go right to the county commissioners about why we did what we did. And I will probably provide David my comments that he can, if he wishes to include in the staff report about my logic. Because I think it's important that, number one, they understand the logic we used individually, not collectively, because this was not easy. I'm still troubled by downzoning. It still bothers me because I don't believe in it, and whether it's technically not a property right issue, it is for the people whose land would be impacted. And while it's not a taking, it is also a loss of income for the people that are impacted. So we could have a legal answer, but there's real impact on people when you make a decision like this. But also, what I want to explain, like I talked before, is the tribe's authority to influence the decisions on land within the borders. If you don't agree with that, I respect that. But I want to make that clear as the reason I made that decision, because tomorrow, if we had a similar situation outside the tribal area for very much like this, my answer would be much different than it is for this area in a very specific area based on what the federal government provided back in 1870-something, I think, or whatever. So this,
Because I'm a big fan of everybody being heard, and I love this idea that the commissioners have to make the final decision and not us. Pardon me. What's the protocol for just what they're saying? Do we give you our reasoning or write something up and send it to you, Mr. Callahan, then you forward? Is that the protocol?
There's not protocol per se, but I am more than happy to be the conduit. Unless you tell me otherwise, I will forward everything that any of you send me to the board, for the same reason that I would forward anything I hear from the public or anyone else to the board, because it's a legislative process.
Correct, and it would be any, concurring or dissenting opinions from individual planning commissioners would be part of the record for the board to consider, so, and should be, so.
but in John's question, make sure, would his be attached to the minutes of this meeting, if you wanted it to be, as well as provide to the county commissioners, or?
It could be. I don't think there's anything preventing that, or, if you wanted to write a concurring
Okay.
opinion, stating, what your thinking is, or
Right.
Lee's or whoever's. We can
Okay.
certainly, it would, regardless of the format, it would be part of the record for the board to consider.
Because I know, Pat, in the past, you've made it very clear that it's important that the county commissioners understand the logic about why we do things. you
Yes,
know,
I
and
think we
the
had
more-
had that discussion when we did our comp plan update.
Yeah,
so.
the more they know, the more they could evaluate it. They can disagree with it, but that's okay, but at least they understand it. And, okay.
Deadline, what will be a deadline to get something done?
We don't actually have a date set, so we have time.
Yeah, because they have to give a 30-day notice.
Right. And we haven't picked a date, so
Yeah.
we have time.
Okay, if we're done with this part of it, we do not have a workshop scheduled as of now. And I've only heard from one commissioner on availability. So please send me your availability for April 13, 20, May 4th, 11, and 18.
Can we ask, David, when do you think you'll be ready for minor subdivision?
Yeah, that makes a
Now,
big
the
difference.
subcommittee sent you the comprehensive plan analysis.
You mean we're not done, you can't go home?
No, we're gonna go home. We're home for now.
He's trying to set you up for something.
It's fair to say that the planning staff is overwhelmed, hasn't looked at this, and probably won't.
Okay.
What I'm going to try to do with the board is see if I can hire SCJ to help us with this.
Okay. So really, we have to wait until we know what the agenda, when you're available.
Yes, sir.
Agenda
I'm sorry.
No,
The staff's just
we
burdened to the point
Totally.
where it's gotten ludicrous, frankly.
And you still want to put Title 8 and
Yes.
the minor subdivision together?
Well,
It would be easier.
but I think we could take out the notice and $1,000 fine provision and go forward with that if you were interested in that,
That's
just to get
Title
it
8.
out of the way. Because
If you want
that
to
was
do
less
that.
controversial,
Oh,
easier to
absolutely.
understand, and
Right. I mean, we can do that.
I'd be in favor of just getting that off the plate.
Okay.
Yep.
Then let's,
It'll be a very,
we talked about doing that May 25th, I think it was. And
Right.
has that been noticed at all, or did?
no, it hasn't
Okay.
been, but we still have time.
Sure. So tentatively, if you get the notice out, we head for Title 8 then? Okay.
Yes.
Okay. Any more business? Anyone want to bring anything? Okay, then we will adjourn at 2:48.
Bye.
bye-bye, Sherry.
Goodbye.
Thank you, Commissioners.
Thank you, that was a good discussion.
Yeah, it was.
Thank you, David.
Yes.
Making a motion.
Thank you.
I didn't ask her as many questions as the rest of you, but I learned a lot.